Hello, and welcome to Scholars Hub at Home. I'm Carrie Williams, Associate Director, Alumni Events at York University. Thank you for joining us for today's special edition lecture, Law in the Time of COVID, Pandemics, Protests, and Emergencies, with Professor Alan Hutchinson from the Osgoode Hall Law School. Today's session is an addition to our regular programming to learn more about the Emergency Powers Act and its recent enactment in response to the Ottawa protests and border blockades. I accept the responsibility to acknowledge the land I am on. Because we are not all gathered in the same place, the land I'm about to acknowledge might not be for the territory you are on. Please take responsibility to acknowledge the traditional territory you are on. Native-land.ca is a good resource for this. As a member of the York University community, I recognize that many Indigenous nations have longstanding relationships with the territories upon which York University campuses are located that precede the establishment of the university. York University acknowledges its presence on the traditional territory of many Indigenous nations. The areas known as Toronto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat, and it is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, which is an agreement to peaceably care and share for the Great Lakes region. I'd also like to acknowledge the devastating attacks on Ukraine. Many of our community members, both alumni and students and faculty, are from and have ties to Ukraine. Our thoughts are with them, their families, and loved ones during this harrowing time. We have moved into the next phase of York's safe return to in-person activities on our campuses. All members of York's community share responsibility for the safety and well-being while on our campuses. And as always, we will continue to monitor the pandemic and share any developments that impact our community and campuses as quickly as possible. Please continue to check our York U Better Together website for the most current information and ongoing updates. We would like to get to know a little bit about who's joining us today. We do have one question that should appear on your screen now. The question is, how would you rate your knowledge regarding the topic of today's presentation? So that should pop up on your screen. I'll give everyone a moment to respond. So again, today's topic is law in the time of COVID. So we'll just give everyone a moment to respond. And okay, so about 60% of you are somewhat informed and about 40% minimal. So, and some very high. Okay, so that's very helpful for Professor Hutchinson to know sort of who he's speaking with today. So thank you very much for that. If you need help with the Zoom webinar, please feel free to click on the Q&A button at the bottom of your screen, and our team is ready to help you. That same button may be used to submit questions to our speaker during the Q&A period that will follow his presentation. Please know all of your comments and questions are visible to our speaker, myself, and staff working behind the scenes. We ask you to keep your comments relevant and respectful. Today's talk features Alan Hutchinson, who has been a professor at Osgoode Hall Law School since 1982. During that time, he has also held a variety of visiting appointments around the world, including University of Wales, University of London, and the University of Sydney. He is a distinguished research professor at York and a legal theorist of international repute, and has published and/or edited 3 books. We are so pleased that he could make the time to join us here today. Welcome, Professor Hutchinson. You may turn on your camera now. We might need to get you to share your slides yourself, because we've had some difficulties on our side. Oh, your sound is off. Yeah.
I think I can do that.
Wonderful. Thank you so much. I'll see you at the Q&A.
Okay, so let's first of all share the screen, and hopefully this is going to work. So people can perhaps tell me if they can see the PowerPoint that I put up.
Yes, we can see it. Thank you.
Good. Okay, so just let me sort myself out here. Okay, so law in the time of COVID. This is obviously a take upon the book by Gabriel Garcia Marquez, Love in the Time of Cholera. And the theme of that book, among many, is that love is both a disease and a cure. And that we go through the world trying to negotiate between the cure and the disease. And in a sense, that summarizes a little bit about my sense of law. It's both a cure, but it's also a disease. And people expect great things from law. And I want to suggest that, like love, it can be rather disappointing. So the first thing to say is when we talk about the pandemic and emergencies, we've been here before. And I've just got three slides which encapsulate some of Canada's recent history. 1970, the October crisis in Montreal, the troops hit the streets. The other one is, this is from Oka, the dispute that people will remember. And another one is the G20 summit in Toronto. These were all what might be called emergencies. And in each of these, I think it's significant that law was basically missing in action. That one of the things lawyers like to think is that we're on the front line, that we're the people who do some of the heavy lifting for society. But I think what the pandemic has done is bring attention to people that when the going gets tough, it's not always lawyers who get going. In fact, if they go anywhere, many lawyers seem to have disappeared during the pandemic. I mean, it's understandable at some level that the courts shut down. But when the courts shut down, this creates problems. The government are on their own, and insofar as we think that courts should be there to keep government in check and to represent people's rights and to defend them, then during stretches of the pandemic, it would seem that that isn't the case. And so when you look at what courts are doing, what lawyers are doing, like most people, they stayed home. And while again, understandable, it's also something we need to think hard about. And it does say something about law generally, and I want to do this before I talk about the actual emergencies, is that law is like a big oil tanker. It's not nimble, it's not very responsive, and it takes a long time to turn around. And so people want to look to the law and think, what's going to happen? Are the courts going to help us? And the answer is likely not. And so you think about some of the things that have been happening during the pandemic. You think about border crossings. We've restricted border crossings. Most importantly, we've restricted border crossings between provinces. People weren't allowed to travel. The Atlantic provinces in particular said, that's it, people have got to stay out. There were mandates. Various institutions, various private bodies were obliged to close. People had to get vaccine passports. People still have to wear masks. And of course, there's a pushback against all this. People say, well, you can't do that, government, because you're offending our constitutional rights. Now, I'm not against some of these measures that occurred, but I think when they did occur, the courts just are not part, really, of what goes on. And lawyers seem to be, as I say, missing in action. But even if the courts were in action and working, as opposed to what they normally do, which is they react after the fact, and often a long time after the fact, then what about the Constitution? One of the things that was in the heart of the protests that occurred in Ottawa and some of the border crossings into the US was this notion that the government were exceeding its authority. They were trampling on people's rights. So where's the Constitution? And by the Constitution, people really mean the Charter of Rights and Freedoms. Charter of Rights and Freedoms, of course, are important and define ourselves in part. As Canadians, we get all kinds of rights under the Constitution. And the relevant ones here were freedom of expression, freedom of assembly, freedom of movement. But if you look at what the courts have done here, it's always the case, as laid down by the Constitution itself, that these rights are fundamental, but they're not absolute. Indeed, Section 1 of the Charter of Rights states that we get all these rights, but they can be controlled within reasonable limits as explained within or defined by a free and democratic society. Reasonable limits that can be demonstrably justified in a free and democratic society. So the Constitution really puts into play the main conundrum, challenge, dilemma of politics is, how do you balance off people's rights against more general public and collective interests? And that's exactly, in many ways, what was going on with the pandemic. So the Constitution is important, and it does give people rights against government, but as I said, while they're fundamental, they're not absolute. And it would be clear, if we take a rather simple example, that on its face, preventing people from moving from one province to another is clearly in violation of the Constitution on its face. However, in the past, the courts have been clear that constitutional interpretation changes during so-called emergencies and crises. Rights take on a very different character when outside of the normal run of things. And so I want to talk about this in the context of the Emergencies Act. So what can we get out of what occurred when the government decided to introduce the Emergencies Act? And by the government, I mean the federal government. Now, we need a little bit of background. We need to think about what occurred. People bringing their trucks, camping, as it were, living outside of Parliament. And this went on for a considerable amount of time. And much of the rhetoric of the protesters was that they had rights, that they were entitled to do this, and that they should be protected from government interference by the Charter. Well, the fact is that even in normal circumstances, people's rights can be restricted, for instance, by time and place. So the Constitution didn't give people the right to do whatever they wanted, wherever they wanted. They could have been told you can protest, but you can't stop the traffic, you can't prevent these things in front of Parliament, you can't blast horns all night. These are considered to be legitimate, constitutionally defended limits upon their rights. But I think one of the things that people didn't really seem to understand, understandably, is, first of all, the federalism aspect. One of the things that we know, should know, is Canada's a federal country, and we divide powers between the provinces and the feds. It's not that the feds somehow have a greater power than the provinces. We divide up different topics into the responsibility and authority of sometimes the province and sometimes the federal government. And the basic issue of maintaining law and order is given to the provinces. And the primary responsibility, some might argue the exclusive responsibility, of dealing with these protests was that of the provinces. And when we know about Ottawa in Ontario, the Ontario government were very slow to react and deal with it. In fact, behind the scenes, we can reasonably assume that the province didn't want to deal with this and were happy to leave it to the federal government. But the issue is that the federal government do not have direct and obvious powers under the Constitution to step in these kinds of situations. And so because of this, and as a result of the fact that acts like the War Measures Act, which was used in Quebec in 1970 by the federal government, was seen to be quite inappropriate. And so the Emergencies Act was passed. And this gives power to the federal government to act in emergencies. powers that are greater and more extensive than they would have if there was not an emergency. Now, one of the important things to note is that the Emergencies Act does not suspend the Charter of Rights and Freedoms. People's rights and freedoms can still be exercised. However, they need to be understood and exercised within the context of an emergency. And I think that was important, that it wasn't for the federal government to do whatever they wanted under the Emergencies Act. They were given more extensive powers, but they still had to exercise those within the letter and spirit of the Constitution, even though the Constitution would be more loosely applied in these kinds of emergency situations. The Emergencies Act designates 4 kinds of emergencies: public welfare, which fits a little within the idea of a pandemic; public order, which fits neatly within the protests in Ottawa; international emergencies, which might, but probably isn't the case as regards what goes on now, as regards, for instance, Russia, Ukraine; and also war. These give extensive powers to the federal government when these situations occur. Of course, what becomes important is what defines an emergency, and also what defines each of these different kinds of emergencies. And I'm only going to concentrate on the public order. So the Act says a national emergency is an urgent and critical situation of a temporary nature, which is very important. Some people were critical, saying, well, the government only exercised the Emergency Powers Act, sorry, their powers under the Emergency Act for a short period. That's exactly, in some ways, what the Act intended. So it's urgent and critical and temporary. And it says it must seriously endanger the lives, health, or safety of Canadians, and is of such proportions or nature as to exceed the capacity or authority of a province to deal with it. For many people, that remains questionable, and there are now challenges by a variety of organizations to the initiating of the claim to powers under the Emergencies Act. But it also says or, it doesn't say and, but or seriously threatens the ability of the government of Canada, not the provinces, but the government of Canada, to preserve the sovereignty, security, and territorial integrity of Canada, and many people thought this controversial, that cannot be effectively dealt with under any other law of Canada. Now, what's important here is, while the provinces likely had the powers to deal with the protest, the federal government didn't necessarily, and they defended their introduction or calling into being the emergency on the basis of this. In this case, they claimed it was a public order emergency. And again, the statute says this means an emergency that arises from threats to the security of Canada, and that is so serious as to be a national emergency. Well, many people would say, how could it be a national emergency if it's only occurring in Ottawa? How is it actually threatening the security of Canada? All these things are very much open to debate. But I've only got a few minutes, and I will say there's a process towards this. The state of emergency is declared by the Governor General on the advice of the federal government. It has to occur after consultation with the provinces. And once it's brought into effect, then it needs to be approved by Parliament within usually 7 days. All these things were followed. So the emergency can be declared and powers can be brought into effect after consultation with the provinces, but before approval by Parliament. The Act itself grants a significant number of powers to the federal government, which they would not normally have outside of an emergency. And one of the important aspects, which is yet to come, is that there needs to be a report by a specially designated parliamentary committee that looks into all dimensions of the exercise of these emergency powers. So I've spoken for 20 minutes, but just let me conclude by saying, as you know, we saw that the federal government moved in once they'd declared an emergency, shifted the protesters, their vehicles, they've arrested people, a couple of those people remain in custody, and like typically most Canadians have now moved on, but there will be a continuing debate about whether the federal government were right to exercise their powers. But an important point, as was clear in the Quebec crisis in 1970, you act first and worry about legitimacy later. Interestingly, it was Trudeau Sr. who acted in 1970 and Trudeau Jr. who acted just over 50 years later in regard to what happened last month. So I'm happy to answer questions. 20 minutes is not a long time to lay this out, but that's me. Thank you.
Thank you, Alan. That was great. You can stop sharing your screen now. While you do that, I just want to apologize for the challenges that we had with screen sharing today.
No problem.
Came through. So it is time for Q&A. That was agreed. We know you had to fit a lot in 20 minutes, but lots of information in there. So thank you for that. Please feel free, audience, to use the Q&A button at the bottom of your screen to ask your questions. And for those of you who are watching live on Facebook, you're welcome to submit your questions or comments through the comment section of the video, and the team will get them right away. Now, are you able to stop sharing screen, Alan? Unless you want to keep that up, you're welcome to. If you like, it's up to you. So while you're looking at that, just so they can see you, we have a question from Luigi. And his question, or her question, is, could the Ontario government have put an end to the Ottawa occupation? Oh, your sound is off. We cannot hear you.
Yes, is the answer. Next question. No, I'll say a little more. I think, you know, one has to be, one has to look at politics here. I don't think the Ontario government had much of an appetite for this. And some would say, well, it should have been federal because this was a demonstration directed at the federal government and outside the federal parliament. But I'm one of those who believes that the Ontario had the power to do what it did. In fact, it introduced its own emergencies legislation. It utilized that at Queen's Park, and also, hopefully I've got the right bridge on, the Ambassador Bridge going into the US. I think they could have done this, but they didn't want to, and they left it to the federal government.
Okay, thank you for that. We have a number of questions coming in. One comment from Robert, who says, your presentation was excellently clear. So there you go.
Good.
I don't know if you want to elaborate a little bit more, but we do have a question from Peter. It says, thanks for your very clear and comprehensive summary. But what is your own opinion on the federal government's invoking of the act? Was it justified and constitutional? A bit more on your opinion.
Yes. I think the federal government really didn't have many choices. The province didn't act. Things were dragging on. There is an issue about whether they should have started earlier. I think there was a lot of popular support for doing this. I think they acted in relatively good faith. I think it's one of those things where people can argue about constitutionality forever. I've spent most of my career arguing about what is and what isn't constitutional. But I think the federal government acted. It may be in the future someone declares them to have acted unconstitutionally, but the argument will be, well, it wouldn't really matter because what counts is what the political response is to their actions. And my sense of that is that while there are some people who are disgruntled by this, most people were happy. I think some of the challenges being brought, one by the Canadian Council of Civil Liberties, wants to establish for the future a more informed and structured framework for invoking the act. But I think as things stand, I don't think they used excessive force or excessive powers in the circumstances. And I'm not, by the way, I should say, I think it's fair to say, I'm not a particular law and order person in things, but this was a reasonable emergency.
Another question for you. You said that as you were going through your presentation, you said this province, Ontario, was slow to react. Can you talk about how that compared to the other examples you shared, the G27 summit, OCA? How did that provincial response compare in terms of response time?
Yeah, I mean, I think one of the things that's quite interesting is on those occasions, the Quebec crisis, OCA, and the G20, my word, did the government come in heavy-handed.
Right.
Heavy-handed is probably a mild description. I mean, the troops went in. Remember, the troops didn't come in this case. And many people raised the point over the last few weeks is that if this had not been a bunch of basically white guys exercising their rights, but had been Black Lives Matter or an Indigenous protest, that the government, either provincial or federal, would have acted much more quickly and much more strongly. And I think there's some truth to that, sadly. So I think that on the basis that they might have done that, it seems that it's a little harsh to say that they shouldn't have acted in these circumstances, because clearly this was a protest that was about much more than the pandemic and vaccine mandates and anti-masking. It was a challenge, I think, to the government generally.
Thank you for that. And it's interesting to understand that response in the context of what's happened in this country.
Yep.
Question from Terry. A number of groups are suing the federal government over its use of the Emergencies Act. What would be the impact if they are successful? The act has been revoked, so what would be the benefit of continuing the challenges? It's a question from Terry.
I'm sorry, you'll have to ask that. Excuse me. You have to ask me that question. I didn't fully hear that.
That's okay. So there's a number of groups that are suing the federal government over its use of the act. And Terry's question is, what would be the impact if they are successful?
I think, as I hinted at, I think, first of all, if they were successful, if you look at the history of courts in dealing with such matters, they tend to be very supportive of the establishment and the status quo. And while it's a fool's game to try and predict what courts are going to do, I would be surprised if they declared the federal government's use of the Emergency Powers Act as being unconstitutional, but they might. But even if they declare it to be unconstitutional, nothing follows from that. Right? The event has now passed. These actions, if they go to the Supreme Court, will literally take years to get there. And it will be, as with many other things that the court declares, it will be a rap on the knuckles for the government. But I think this is something that Trudeau would have calculated that he's prepared to take as long as he retains political support more broadly. And so I think people need to think hard about that somehow courts will move in, one, and declare it unconstitutional. And if they do, that consequences will follow for the federal government. And as a lawyer, I'm not entirely clear what those consequences would be, other than a censure and a warning about this being unconstitutional. But I'm not convinced that that would happen.
Thank you for that. We have a number of questions. I'm just going to answer this because we have this in the Q&A. Yes, we are recording this session and we'll be making it available on our YouTube channel. We'll make sure that everybody gets that. So a couple of people have asked that question. A question from Howard for you. What about the application of the Emergency Act regarding the border crossing?
I assume here we mean border crossings into the US?
Yes, I think so. Let me see the response.
I'm not entirely clear what the force of the question is. These powers can be exercised by the federal government across Canada. They only lasted, I think it was 7 days. They've now been suspended. But the argument is, again, that in these situations, one, the provincial governments have the power to act and to break up these protests at a certain point. And it's arguable, but because these kinds of matters fall within federal jurisdiction, that the federal government might well have normal powers to intervene as regards keeping the border crossings open.
Thank you for that. Comment and question from Dion. Great job, Alan. With the ongoing pandemic, what do you think about the current vaccination policy among various settings?
Well, I don't really have a legal view about this. I think the present situation in my home province, which is Ontario, is that we've set back a lot of restrictions, and the question would be throughout, was this what might be called a balanced approach by government? And there was a case brought by Hudson Bay over the closing of certain private department stores of a large nature, but not other kinds. And the court took a predictable position of saying, look, we're not here to make political calculations. We're just here to say who can do what and when they can do it. And so the courts have been, in general, supportive, although there was a case last week in which a father had asked that a mother be obliged to have the children vaccinated. They were a separated couple, and a judge found that the mother was entitled not to have her children vaccinated. And the court based this upon a notion that the government don't have all the answers to all the problems. But I think in all these mandates, the answer has to be that nobody's required to be vaccinated. It's just if you're not vaccinated, you can't do certain things or mingle with other people. It seems to me entirely reasonable. And I should say, I have 2 vaccines and a booster.
Thank you for sharing that. Lots of questions. So I'm just sort of filtering through them here. Back to Ottawa, a question from Valerie. What are your views with regards to the law case being brought forward by the residents of Ottawa for the disruption to their lives?
Sorry, being brought by whom?
The residents of Ottawa.
Yeah, I mean, I don't know a lot about the details about that, but the residents of Ottawa presumably are suing the protesters.
Let's see what she says.
I mean, I'm assuming that's the case. They're going to sue. Maybe they're suing the federal government because they should have acted earlier. I don't think that'll be going very far. I can understand that. I mean, I assume that these kinds of actions are brought because it's about drawing attention to matters. It's about trying to ensure that these things don't occur in the future, but without any more information, I'm not entirely clear what the basis of their action would be, then therefore their chances of success.
Okay, yeah, I've heard that they're bringing a case forward, but I actually don't know the specifics of it. But certainly the coverage made it very clear that it was very beyond disturbing for to their lives. So question from Barry. Barry asks, although the courts may have been slow, the court did give an injunction to control some aspects of the honking, the noise, and there was a 306 civil suit launched. How could the court have been faster? So again, this question around
have been faster. Well, those 2 words don't go together very well. Fast court.
Yes, you said it was an oil tanker. I think you said.
But I think that if all this had occurred more towards the beginning of the pandemic, it would have been extremely difficult because most courts were closed. Now, they would have made themselves available for emergency measures, and after a certain time, virtual hearings began to be utilized by the courts, but it took quite a time for them to get going on this. But I think this is where, as I said at the beginning, the legal process is a very cumbersome process. And it's not easy for courts to operate quickly and to respect various people's rights. They have done this, but it doesn't happen often. And as I say, it's highly unlikely that the courts will wade into extremely controversial and contested areas, and that their overall track record is to side with the establishment in these matters. And sometimes that's good and sometimes that's bad.
Okay, I am seeing there's some challenges with my my sound. So I'm going to speak louder and slower to make sure that you can hear me. Some of the audience is saying they're having trouble hearing me. A question from Enrique, and this is again a question sort of in the spirit of learning about this act. This question is from Sam. Is unanimous agreement from all provinces and territories needed for federal government to invoke the powers?
No, my understanding is, excuse me, the act requires consultation, but it doesn't require the approval of the provinces. So consultations must occur, but the federal government is entitled to act after the consultation, and presumably that consultation will be taken seriously and might well affect the decisions by the federal government. But the act requires simply that they consult. However, after they've declared a state of emergency, they need the approval of Parliament, and they need a majority vote upon that. And if you'll remember, we have a minority government, so they required one of the parties to support them. Excuse me, I don't know why I'm losing my voice. And the NDP supported the Emergency Act, and the Conservatives didn't.
So thank you for that. Following up on that, Greg has a related question to that. And again, looking for your opinion, your views. So your views of proposals to amend the Emergency Act such that one, MPs are allowed to vote based on their conscience, not the party lines. And two, the vote is not a vote of confidence in the government.
I'm sorry, is it being suggested that that should occur?
Yeah, so Greg is asking what your views are. I guess these are proposed amendments to the act, that MPs are allowed to vote based on, not just based on party lines.
Yeah, I mean, I think the first one is any MP can vote however they want. If they want to go against the party, they can, but there will be repercussions from them from the party. You don't need an act of Parliament to tell MPs that they can do that. Also, there are no rules of Parliament. There are informal conventions around the issue of a vote of no confidence. And whether the government decides to see it as a vote of no confidence is not governed by a detailed set of rules. So if they had been turned down and seeking to, they'd already invoked the powers, but getting the approval of Parliament, then this wouldn't necessarily lead to a fall in the government. And this would be decided in line with the political sensibilities of the day.
Okay. We have a lot of questions. We have a few more if you're up for it.
Sure.
Okay. Another question from Luigi. Question is, what is the likelihood that occupiers will face legal consequences, either criminal or civil? And would those serve as deterrents for future occupations, in your opinion?
Well, I think they will face consequences. As I said, many people, I think it was something like 150 people were arrested and charged. Some were kept in custody. There will be consequences to that. I think most of those won't be particularly severe consequences in terms of imprisonment, although that might not be true for the ringleaders. Will this work as a deterrent? There's no absolute or final answer to that. There are people, and it's quite interesting, in the past, there are people who have continued to engage in what would be declared illegal activity. We sometimes describe those people as heroes within our society, and other times we just consider them to be criminals. So I think whether people are deterred really is a personal question that people will have to decide. So the protesters will decide whether they wish to become silent or whether they continue to be martyrs to their particular cause.
Okay, we have time for one more question. Thank you for that. This one is from Doreen. Okay, from Doreen. With the government becoming, sorry. Okay, I'm going to read this question. It's long, so let me read. So, with the government becoming the act under the premise of it falling under a national emergency, so with the government saying this falls under a national emergency, could this position have been taken on the pretense that other countries and governments would follow suit with protests, which could then justify the position that this was done under the context of a national emergency?
I mean, it'll be interesting that when these challenges occur, the federal government will be represented and will need to provide a rationale, more detailed than they've given up to now, as to why they invoked the Emergency Powers Act. I think a whole variety of arguments will be used and relied upon. There's no particular formula that the government has to follow. But I think that, you know, trying to get a sense about where the political winds are blowing, I'm not convinced that this will be a difficult issue for the federal government, although a court might ultimately recommend that certain matters be taken more seriously in the future. We also have to remember that it was just slightly over a year after the American problem at the Capitol buildings in Washington on January the 6th. And obviously there was some kind of fear that a similar riot would ensue. Some people think that what occurred was as bad as what occurred in Washington. But I think one of the messages I want to get across to people is the Constitution and law is a much messier, indistinct process than many people believe. There are not hard and fast answers. And I think the courts are smart enough to know that they need to take into account popular views. Doesn't mean they're hostage to popular views, but they get a sense of what people think. After all, they say it's our Constitution. It's not something that's written in stone somewhere.
So context, they're constantly taking.
Context is hugely important.
Yeah. Okay. Well, Professor Hutchinson, that has been such an informative lecture and such a lively Q&A. Thank you so much for your time and for joining us today. Lots of comments in the chat about how excellent this information was and how excellent your presentation was. So thank you so much.
My pleasure. It's all part of the job, as they say. Thank you.
Okay, take good care. You're welcome to turn your camera off now if you'd like.
Will do. Thank you.
Okay, you're welcome. For those of you who would like to share today's session with family or friends or rewatch it, as one of our audience members asked, it will be posted on our YouTube page at youtube.com/YorkUalumni. You may also watch any of our past lectures that you may have missed. We have one last question for you, and it should come up on your screen now, and that is, how would you rate your knowledge of today's topic following Alan's presentation? It should pop up on your screen now. We return to our regular schedule on Wednesday, March 16th with Dr. Cora Young, Associate Professor from the Department of Chemistry with her session, Do Clear Skies Need Clear Air? Pandemic Lockdowns and Their Influence on Air Quality. And on Wednesday, March 30th, we will have Assistant Professor Emily Laxer from the Department of Sociology at Glendon College with her session, Populism, Legality, and the Politics of Diversity in Canada. You may learn more about these events and all of our events at yorku.ca/alumni and friends. Thanks again for joining us today for this special edition. Please take care and be well.